Welcome to Arbitration Acumen, a podcast from Bracewell's International Arbitration Group that connects in-house counsel and arbitration practitioners with industry experts, institutional insiders, and top arbitrators from around the globe to share their views on key issues in arbitration today. You can reach out to any of today's speakers by emailing arbitrationacumen@bracewell.com. And we hope you enjoy this episode of Arbitration Acumen.
Welcome back. We'll discuss JAMS and its international practice with Sherman Humphrey, who's the Associate Director of Global Practice Development at JAMS, and Bob Davidson, a Chambers-ranked international arbitrator and mediator based in JAMS's New York office. I'm JP Duffy. I'm an international arbitration partner based in New York that acts as both counsel and arbitrator in international arbitration seated around the world under a variety of governing laws and arbitral rules. I'm qualified in New York, England and Wales, and the DIFC courts in Dubai, where I previously practiced. As I mentioned, joining me today is Bob Davidson, who was the dominant draftsman of the JAMS International Arbitration Rules, and who's the executive director of JAMS Arbitration Practice. He's one of the leading international arbitrators in the United States and has been listed as such in chambers for each of the past 10 years. He's arbitrated as sole arbitrator, tribunal chair, and as a member of the tribunal acting under the rules of most prominent arbitral institutions, including, among others, JAMS, the ICC, the ICDR, the LCIA, the Netherlands Arbitration Association, CTAC, the HKIAC, and UNCITRAL. He's arbitrated cases involving virtually every commercial area, and while in practice, he acted as lead counsel in more cases before the Iran-U.S. tribunal than any other lawyer. And I can say from having seen Bob in action as an arbitrator, he is truly exceptional and truly a standout on the global stage. Also with us today is Sherman Humphrey. Sherman is based in Miami in Florida and is the Associate Director of Global Practice Development at JAMS, where he drives industry engagement, thought leadership, and innovation in cross-border alternative dispute resolution for JAMS. Sherman joined JAMS in 2012 as a business manager for the Miami Resolution Center. And during the time that he's been with JAMS, he's overseen the opening of JAMS's 2 South Florida offices while managing operations, case administration, and client service processes for JAMS in Miami. So as you can see, we have great guests today that can offer a wealth of knowledge about JAMS. So let's jump right into hearing from them. Before we do, though, I just want to give some very short introductory information about JAMS for our audience members around the world that might be less familiar with it. JAMS was founded in 1979 in California and bills itself as the largest private alternative dispute resolution provider in the United States. It handles over 18,000 cases annually in a range of different types of disputes. Sherman, how many offices and hearing centers does JAMS now have across the U.S.?
Thanks, JP. We currently have 27 resolution centers across the U.S. And as you mentioned, originated out west in California. Our founder, Warren Knight, I think noticed that arbitration and mediation was rarely being chosen voluntarily by attorneys and decided that there might be a better way to do things. And that's how the JAMS story starts. Since then, we've grown, as I'm sure we'll jump into shortly.
Now, I know there's a very large office in New York. What are some of in which I think Bob is located? Where are some of the other hearing centers and offices that JAMS has across the U.S.?
We're located in most of the major metropolitan hubs. So everywhere on the East Coast, from New York, DC, Atlanta, the Miami office, which opened in 2012, in the central region, as we call it, Dallas, Chicago, and really spanning the whole country as far, north as Seattle, San Francisco, and far south as San Diego. Naturally, being a California originating organization, I think we have 9 or 10 offices in California, and the rest are spread out across the U.S. in those major legal and metropolitan hubs. We've also introduced what we're calling virtual offices, which are in smaller yet important legal markets where we've experienced demand for JAMS services. So these are cities like Austin, Nashville, Raleigh, and others. We don't have a physical location in those offices, but we do have local panelists in those cities.
Wow, so pretty comprehensive coverage. Now, does JAMS have international offices?
Yes. So in 2011, as we were very keen on expanding our international practice, JAMS opened not only the Miami office, but also a presence in London and Toronto. Our London office, for example, is located within the globally known IDRC space. And so we maintain a presence at this time in those two international markets, London and Toronto.
Great. Now, does JAMS intend to open any other international offices?
Not at the moment. So our focus right now is not on physical expansion, but on prioritizing the strategic international partnerships that we've established and building new ones and creating accessibility for international users. I think one thing that the JAMS is recognized for is collaboration is really a part of our DNA, and that might trace, to our roots in mediation. And so we're pretty deliberate about creating partnerships and a presence internationally via some of these partners, which can include international organizations or other ADR providers.
That's great. Well, that's very impressive growth. Now, when did JAMS International start administering cases?
I wrote the first draft of the JAMS International Arbitration Rules in around 2008, and they were most recently revised in 2021. We've always administered cases that are in fact international, but it got to the point where we decided to count them accurately. And that was done by some administrative oversight of the systems we have, so we could code cases, whether they be mediations or arbitrations, that came in that fit the definition international. We've been doing these cases for a while, but we've been really seriously counting them, I think, since about 2021. And so you ask, when did we start administering? We've always administered these cases just like any other. And then starting around 2008, when folks started using our international rules, that use has happily grown over the years.
Bob, what prompted you in 2008 to draft the international rules?
Well, when I was brought into JAMS, I was, as you know, you were my partner at Baker McKenzie for years, and I did a lot of international work there. And JAMS really recruited me to, I think, jumpstart a large commercial practice and an international practice. So I saw the opportunity, and I saw international cases coming in, and I thought it was a good idea to draft those JAMS International Rules. And that was what really motivated me was the volume of cases that started to grow.
Well, I can't think of a better person to draft international rules than Bob, given your experience. Let's talk about some of the numbers there, because I think that's going to be of interest to the audience. How many international cases did JAMS administer in 2023?
A quick note as to why we're referencing 2023 is a couple years ago, we started producing a formal international case statistics report. And so we're finalizing our report for the 2024 year, and we'll be sure to let you and all of our colleagues know when that's ready to come out, typically in April. In 2023, JAMS handled over 400 international cases. That represented about 241 new filing. So in terms of, there's a distinction there between the cases that we handle and the cases that were filed.
And what industries did those cases typically come from, Sherman?
It's really, JAMS really handles everything under the sun. I think with regards to our international practice, there are a few perhaps areas of focus. Of course, business and commercial disputes, contract breaches, M&A disputes, joint venture disagreements is a big one, which I think is pretty standard across the industry. JAMS is also fairly well positioned for handling insurance, reinsurance, IP, construction, and infrastructure. And we're also seeing an increased demand in the technology and emerging sectors, blockchain, AI, smart contracts, cybersecurity matters as well.
So really, really seeing the gamut. And I know I've had Bob as an arbitrator in pharmaceutical disputes, as well as insurance matters, and I think a few different other industries. So it's unsurprising to me to hear that JAMS cases span the gamut. What countries were the top 5 users in 2023?
So in general, with regards to our international arbitration rules specifically, we're seeing those cases most frequently originally from common law jurisdictions and, of course, key U.S. trading partners. So I don't think there's any big surprises there, but the UK, Canada, Australia, Singapore, China, Mexico, and EU. But I mentioned those in no particular order as those rankings, I would say, fluctuate across the years.
Yeah, we've also had a growth in the Asian area. We have cases that have occurred in Hong Kong and one or two in China. And so that area of the world has become something of interest. I myself have had 2 cases in Hong Kong and 2 with CTAC in China. So we are starting to penetrate that market as well. JAMS International Arbitration Clause is finding its way into contracts in that part of the world as well.
That's really interesting. Now, Bob, are those cases that are seated in that part of the world or involving parties from that part of the world?
Well, both. My CTAC cases were seated in Beijing. The Hong Kong cases were in Hong Kong at the premises of the Hong Kong International Arbitration Center. And I have seen one of the things in the rules is that we vet the awards prior to their issuance, and I'm on the committee that does that. So assuming, of course, it's not my case. So similar to the ICC, only it's a kind of light review. It's not a very detailed review that takes a significant amount of time. And as to that, I have seen cases under Chinese law or cases that came out of China that were not physically located in China, as well as several that were.
Interesting. Well, that's certainly a burgeoning market for many, many people. So it's good to hear that JAMS is getting traction there. One question I have is, what are there market segments? We've mentioned a lot of different jurisdictions and different practice areas. Are there specific market segments that JAMS is targeting for international cases at the moment, or in which JAMS would like to see more growth?
Perhaps Sherman. I mean, we have had promotional efforts, I think, and whether they be podcasts or whether they be events. I know we've had them in London. We've had our people participate in various jurisdictions in Europe. I can't put my finger on any specific practice area other than perhaps intellectual property. I know we've been seeing significantly increased practice in IP. That'll include patent claims, even patent claims under European patent. And of course, pharmaceutical license agreements really span all over. Also, a significant amount of insurance and reinsurance cases. Those usually involve a party out of London. Not always, but usually, and sometimes, of course, Switzerland.
One thing I'd like to tack onto that is that JAMS, I think naturally, because of our strong U.S. domestic presence, many of our matters have a U.S. element. And I think that parties in international disputes that involve oftentimes a U.S. party, and where they anticipate that the potential disputes that may arise from that require experienced neutrals with deep subject matter expertise with a U.S. angle is one. So, outside of a specific market segment, but almost types of disputes that may arise. And JAMS is also recognized for having very flexible, efficient, and party-driven processes. And so I believe that when sophisticated parties anticipate the need for that type of flexible and efficient approach, that is another reason that they're selecting JAMS. There are, as Bob mentions, I think industries where we're seeing the most growth. Many of those are probably in line with what other ADR providers are seeing around, technology, life sciences, but we're also seeing, growth in construction and commercial disputes, of course.
Interesting. Well, that all makes a lot of sense, given what JAMS does and who the parties are. Now, let's talk a bit, if we could, about the JAMS International Rules themselves, because I'm sure that's a large driver of why parties are choosing JAMS as the administrator as well. Bob, if I'm correct, the current rules took effect in 2021, right?
Right.
Great. What are some of the salient features of those rules?
One of the things that we do have is a party-appointed system. The parties get what they ask for, and the rules, as for the appointment of arbitrators, follow basically the ICC format, which is one party picks one, another party picks a second, assuming there are three, and the two so selected pick a chair. The thing about the JAMS rules that not everyone might understand is that you can select any arbitrator. It doesn't have to be from JAMS or from JAMS's panel. We've had cases under the JAMS International Rules and administered by us with 3 arbitrators, none of whom were, in fact, JAMS neutrals. So you get what you select, you get what you ask for. And the procedure for selecting arbitrators in Article 7 of the rules is not so different from other organizations. Article 7 of the JAMS rules provides for a process for selecting arbitrators if the parties cannot do so themselves, and it's by a list of procedures. We also have rules, as the other international organizations providers do. We have a process for challenging an arbitrator. We have to have disclosures that are in fact made by arbitrators in the same manner as they would be in most international cases. I think ours are a little more rigorous in that we are U.S. based, and therefore we have rules that guide us in the disclosure of any conflicts. And, it isn't just anything that we think might affect our neutrality or impartiality. It's specifically any relationship to the parties or counsel. Have we sat before with any of the other arbitrators, etc. We also have a joinder and consolidation rules that provide that if separate cases are filed, arbitrations are filed, an application can be made to consolidate them. And the JAMS International Arbitration Committee, which is made up of a small group of people who are very experienced in these cases, will make the decision about whether or not consolidation will be permitted. We also have joinder rules that says that if a third party wishes to join in the arbitration, that decision will not be made by the committee, but will be made by the tribunal itself after consulting with the parties. We have a couple of interesting provisions. We have rules that deal with the granting of emergency relief and the appointment of an emergency arbitrator. Those rules are similar to the rules of many of the other international providers. What we have that is unique, and I'd like to point out, our Article 31 on interim measures of protection provide that the party can request an interim measure, and the standard for granting it, they have to satisfy the tribunal that harm not adequately reparable by an award of damage is likely to result if the measure is not ordered, and such harm substantially outweighs the harm that is likely to result to the party against whom the measure is directed if the measure is granted. And B, that there is a reasonable possibility that the requesting party will succeed on the merits of the claim. Now, that is a standard that is the UNCITRAL standard. And to my knowledge, we are the only international provider that provides that an interim measure can be granted on that basis. It does away effectively with the need for showing irreparable harm. And it also does away with the need to show a likelihood of success. All you have to show is a possibility that you'll succeed. It's a much easier standard to meet. And we've received significant commentary on that provision, which we did put in the rules in the 2021 version. And that's really, we have the usual procedures. You've got a preliminary conference. You have the ability for reasons of health or other reasons, the arbitral tribunal can direct that the proceeding or part of it take place by Zoom or by other remote means. And the whole set of rules is geared to doing this efficiently and as quickly as possible. Parties are rightfully complain often about the cost and the delay in trying to get from the appointment of a tribunal to an award. And our goal is to do it at a reasonable cost and as quickly as possible.
That's really great. I want to highlight a couple of things actually. One, I think the notion of really working on making the standard for emergency relief easier to hit is great, because that is certainly something that has become much more important around the globe, particularly in a lot of the industries that you both mentioned earlier, life sciences, insurance, IP, right? Those are typically industries in which you will see emergency applications at the outset these days. And the other thing I wanted to highlight, Bob, just for the audience's benefit, is your earlier comment about in international cases, the ability to appoint arbitrators that are not on the JAMS roster. I think that that's something that probably a lot of people are unaware of. And it's a really nice feature because it really does highlight party autonomy. And certainly it sounds like the JAMS International Rules, unsurprisingly, since you drafted them, are really congruent with all the international rules around the globe.
One other thing that I'd like to mention, it's important about JAMS, is that the cost of an international arbitration. Many of us, when we were in practice, and then, of course, clients who are using provider rules get terrible sticker shock when they get a bill for commencing a case. And that's because many of the international providers bill on an ad valorem basis. In other words, the higher the amount of controversy, the more one would pay to file a case and for the arbitrators. JAMS doesn't bill that way. JAMS bills based on the time of the arbitrator. So the arbitrators will bill their time at usual rates, and 13% will be added to that, and that will be JAMS administrative fee. If you're going to use, let's say, one arbitrator as opposed to three, it is significantly less expensive. It's about 2/3 less expensive. If you're going to use three and it's a very large case, you're going to have a very lengthy process in order to reach the kinds of numbers that will reach you with many of the other international provider organizations. So JAMS can be significantly less expensive, and you should think about that. Also, and this is also a substantial advantage, I think, is that JAMS is known not just for arbitration, but for mediation as well. In fact, of the 18,000 cases that Sherman mentioned, I think about 10,000 are mediations and about 8,000 are. If you're looking towards resolving this case midstream, let's say, or prior to a lengthy hearing, the use of our rules and our administration will be significantly less expensive. First, because you can, of course, mediate a case at any time. And there's a whole wealth of experienced world-class mediators. You can choose, it doesn't have to be a JAMS mediator. It can be anybody that you want. But mediation possibilities are always there. And if you're going to resolve the case, it's obviously going to cost less because of the fact that your fees are based on a 13% override of the fees charged by the arbitrators. So there are cases in which a significant amount of savings can be realized.
Well, certainly anything that is going to save parties money these days in the international arena is going to be welcome news, right? I mean, I think you're hitting the right note with that, because it has obviously always been a discussion point that costs are increasing in international arbitration. But I think within the last year in particular, there's been a real focus on getting back to reasonable costs and reasonable efficiency. So that will be music to many, many users' ears. Now, it's also unsurprising to me that the mediation numbers are really high, because you do have so many people that associate JAMS with a certain profile of arbitrator and mediator, which is very, very high caliber, right? So one of the things I think would be interesting for the audience to hear about, Sherman, is the JAMS roster. So obviously, Bob has mentioned you have the ability in an international case to choose whoever you want. Sometimes that works, sometimes that doesn't. Maybe you end up in a default procedure by which you have to appoint from the JAMS roster. Let's talk a bit about that. How big is the JAMS roster?
Currently have around 450 neutrals, as we call them, or panelists on the JAMS roster, the majority of which are based in the U.S.
And what are some of the basic requirements to become a member of the JAMS roster?
As unlike other institutions that may have an application process or even an application form, JAMS, I should say that JAMS, one reason for JAMS success is that we build our roster with great care. So JAMS neutrals are carefully selected through an invitation process. This ensures that we maintain a high caliber of experienced mediators and arbitrators. They undergo a pretty rigorous vetting process, which includes peer evaluations, client feedback, conflict of interest screenings. We, of course, prioritize individuals that may already be recognized for their neutrality, their legal expertise, and of course, their industry experience, and that they are really primed to handle complex disputes effectively in addition to the training that they're provided when they join JAM.
One of the things that I want to emphasize that Sherman said was that, if you want to become a JAMS neutral, you don't just send an email and say, send me an application form. JAMS has to...
So we do get that a lot.
Yeah, we do, but it's routinely rejected. What we do is we invite people to join the panel. We have groups that meet periodically and say, well, who is a recognized force in the ADR field, or who has recently announced retirement from the bench that might be valuable, and then we will go out and actively recruit. There's a misperception that JAMS is made up substantially of retired judges. While we have a significant number of retired judges, many of our neutrals are not retired judges. They're people like myself who came out of private practice, who may have retired from large firms. And one other qualification is that you have to be a full-time neutral. You can't stay at a law firm at like a senior counsel or something and then, have the hobby of being an arbitrator once in a while. You have to commit to doing neutral work full-time. And we find that avoids problems with conflicts, and it also encourages people who are thinking of joining an organization or becoming a neutral to actually take that big step and sever ties with their firms. So that's what I have to say about that, which is actually quite important. You get a pool of very experienced.
That is a real differentiator, Bob, but I just want to highlight too, because I think, like I'm on the roster of several different organizations. I select as counsel, obviously. I think the difference between that and someone who is a full-time arbitrator really is a distinction. You were really committing, as you say, to be full-time neutral and have none of the baggage that goes along with being associated with counsel work or a firm.
Yeah.
So that is a real distinction. Now, you mentioned people getting together to invite members to the roster. Are there regional committees, national committees? How does that work?
Well, I can tell you my own experience. I have in a few weeks, I have a small meeting here in New York with several JAMS neutrals and one of the administrative people, and we're going to go over a list of names that have been suggested. We will talk about it, and the end result will be, well, maybe we should talk to Ms. X or Mr. Y and see whether they have any interest, or we may just pass, or we may say, well, the indication is that he or she is going to continue to work at their firm for several more years, and we'll put it on the kind of wait list. But there'll be smaller meetings regionally where possible recruits will be discussed.
No, that is a real distinction though, because that's a true methodology of picking people that are expert in their fields because they're being selected by people that really know what that means. So that's really wonderful to hear. Now, let's shift gears a bit and talk about what is in the future. You're talking about future members, so it's a good transition to talk about how 2025 will look.
Sherman's probably going to say the same thing, but in Miami, and most recently it was recorded again for the ABA dispute resolution section. We had a program on cryptocurrency and blockchain, and that was suggested and done because of the increase we anticipate, and some of which we've seen in these areas. We have specific AI rules at JAMS, the JAMS Artificial Intelligence Arbitration Rules. So we are primed for what we think is going to be a significant increase in these cases.
Bob, when were the JAMS AI rules released? Because I just saw today, I think CIA ARB put out AI rules very recently. It sounds like JAMS has predated those. When were those released?
I don't have the data on that, Sherman. Do you?
I think it was sometime over the summer in 2024.
And is JAMS seeing a pretty significant increase in the number of crypto cases it's administering?
We're tracking those numbers is what I would say. I would say the interest and the amount of inquiries coming in from companies that operate on the blockchain is definitely increasing. And I'm hoping that we can share some numbers around that pretty soon.
Great. Well, if there's one thing you'd like to see JAMS accomplish in the international arena in 2025, what would that be?
I'd say, the world is a big place, right? And we're not trying to be everywhere all at once. And referencing a previous comment about our DNA, we want to see growth in the ADR industry in general, not just with JAMS. But I'd say one key priority for us in 2025 is to expand the adoption of JAMS arbitration clauses in cross-border contracts. Bob referenced our international rules being relatively new on a global scale. And we've also noticed that there is a substantial amount of both U.S. and global companies that might use JAMS for many of their domestic matters. And we're working to raise awareness about our international capabilities with this segment and with the business world in general. So that's always a priority, is increasing that client base.
That's really great. And I'm sure with the amount of effort that's being put into it and the people behind it, that will be a successful undertaking. And what's clear to me is there's so much going on at JAMS right now internationally that we could talk about it all day. And I think what we should do is hopefully schedule a time to continue the discussion in the future, probably later in the year or early 2026, when we can see how some of these initiatives have worked out. But I think with that, we will thank our guests, Sherman Humphrey and Bob Davidson of JAMS, for their invaluable insights. And I want to thank you, the listeners, for tuning in and listening. We look forward to having you tune in for future episodes in the series. Let me just extend a personal thank you as well to Bob and to Sherman for their time today and their invaluable insight. It's really been great and it's really been valuable. So thank you both for your time and your insight.
Well, thank you, JP, for inviting us. It was a pleasure.
Huge pleasure, JP. It's always a pleasure. So thanks for having us. We really appreciate the opportunity to talk with you.
That's great. Well, thank you, guys.
Thank you for listening to this episode of Arbitration Acumen. We hope you found it insightful and informative, and we encourage you to share it with your colleagues if you did. You can reach out to any of our speakers by contacting them directly or by emailing arbitrationacumen@bracewell.com. We welcome any questions or suggestions you might have for future episodes. And please subscribe to our podcast channel to stay up to date with our latest content.